I say anyway, if you want to speak generally in political terms, we don't need activist judges. We do need activist citizens. And that's what I think the Constitution foresees, and that's really why I wrote this little book, because I want to encourage people, particularly, you know, those in high schools and other places, and I can use some authority there in having worked with the Constitution for a certain number of years now, say that I can tell you this about the Constitution. It sets up that democratic system, and that democratic system expects people to participate. And if you don't, you can do what you want, but I'll tell you that document, and this I say professionally, won't work. Now, I say that to high school students, and I say, I'm not telling you what to do, I'm just saying the Constitution won't work. And I say, I know it's a gimmick. I am telling you what to do. But I also think that that participation is important, and, you know, et cetera. So what I think of activist judges, that's what I think.
Justice Scalia, when do you think that the court has crossed the line and decided things that should have been better decided by the political branches, taken away democratic participation?
Well, you know, I've explained my approach, and I would have to say whenever it gives to the text of the Constitution a meaning different from what it bore when it was adopted. Whenever it does that, it is taking upon itself the role of revising the Constitution, and that's something the people are to do, not the court. Let me say something about activist judges. I agree entirely with Justice Breyer that it's a conclusory label. I mean, you know, whop, activist judges. It just means any judges that are doing things you think shouldn't be done. Some people, for example, would call the Rehnquist court an activist court on the grounds that it struck down a much larger number of federal statutes than the Warren Court had done. Well, you know, that's sort of a silly criterion because there is there is such a thing as an activist Congress. And if you're dealing with a Congress that is pushing the envelope all the time, you would want your court to be striking down, even if it's not an activist court. If it's just keeping the traditional bounds of the Constitution, you would want that court to strike down a lot of statutes. So that's no way to judge the matter. Ultimately, you have to judge it on the basis of what you think judges ought to be doing. I would call a judge an activist judge when he, as I say, gives to the Constitution a meaning it did not have when adopted, or gives to a statute a meaning other than its fairest interpretation.
So when you disagree with Justice Breyer on some of the
I would never call him that to his face.
But Justice
And
Breyer,
one thing we do is well, sorry. Sorry.
well, you didn't agree with many of those decisions of the Rehnquist court that struck down some of those acts of Congress.
No, I didn't. And that's why it's so hard to say that I think one or the other of us is more likely to pay attention to Congress. I mean, if you look at the numbers in the Rehnquist court, you'll see, well, probably I was more in favor of the congressional statutes than you were. And where the differences lie, and we're not always on opposite sides, even in this 20% of the thing. But the differences are more lie in the approach to interpretation. I mean, think of how the Warren Court was criticized for being activist even in their main decisions, which is absolutely accepted now, that main decision that was Brown versus Board. And, you know, if you look at it now, you say, my goodness, what could have been more literal? The Constitution says equal protection of the law. It says every citizen is entitled to equal protection of the law. And you simply had to, I'm old enough to remember, you know, and you are too, when throughout large portions of this country, you know, vast numbers of citizens of the United States of America were just treated unequally. That really understates it. They were treated really badly. And anyone who went around and opened his eyes could just look and say, you call that equal protection of the law? Of course it isn't. And what the Warren Court did then was simply say those words of the Constitution in the 14th Amendment, which was aimed to take people at that time in the 1870s who'd been slaves and integrate them into American society. That it was designed to do that, and the words said it, and my goodness, it wasn't being done. And there, I think that was literal and purposive and historical, anything you want to say. And yet at the time, people said who were opposed to that, oh, this is very activist. Well, of course, it wasn't in any sense whatsoever. So beware of labels. And of course, when you talk about philosophical disagreements and approaches towards interpretation, one of the wonderful things about an event like this is you're seriously interested in this question. And you can see what real differences there are. And you can think about them and decide what are appropriate in an intelligent way. Well, we're not the CIA over at the Supreme Court. We are an open organization that tries in every word to put down on paper what we're really thinking so people can read and think about it. And I think that's why we're here, because we think there is a real value in people taking what we're doing seriously, non-politically, trying to understand the philosophical and conceptual differences and think about them and discuss them. And as you can tell, we both like to talk about it and are happy to do so.
And we do not differ as much as our interesting conversation might suggest. I think in a vast majority of cases we come out the same way.
Not all.
Huh?
Not all.
The vast majority.
You're right. I agree.
Vast majority.
I agree with you. I agree with you.
The courts came under, obviously, enormous criticism 40, 50 years ago, and now we've seen some, Justice O'Connor, for example, again express concern about criticism of the courts and concerns about judicial independence. Is that something that troubles you, Justice Scalia?
Having engaged in criticism of the courts myself, I can hardly say it's a bad idea. It depends on how the criticism is put, whether it is destructive, just, judges are, terrible and the court should be ignored or disobeyed or whatever, or whether it's intelligent criticism that says judges are doing this or that wrong and should adopt a different approach. But the notion that all sorts of criticism are improper, I mean, my goodness, that's why we have life tenure, precisely so that we can, let this roll off our back. And it's always been there. John Marshall was criticized much more brutally by the Richmond papers than any of the justices on the current court are criticized in the press. And, I mean, it cut him so deeply that he wrote anonymous letters replying to the criticism. So it's always been with us, and it should be with us. It's one of the checks on the judiciary. The only check once you're in office, criticism from the bar, from the academy, and from the public. So I think it's healthy to have intelligent, constructive criticism. It is, of course, not healthy to have criticism that just demeans the courts and encourages the people to have contempt for the courts. That's not helpful.
If I could also, you were saying you agree, you both seem to agree that you agree on a lot of cases. Our new Chief Justice would actually, and has said he'd like to see more of that, more unanimity, more narrow opinion so that you can reach. What are your thoughts on that?
Lots of luck.